Let's get right into it. Number 10. You belong to the state now. Imagine waking up one morning, stretching your arms, cracking your knuckles, and then being told by a man in a toga that your body is technically government property. Not your soul, not your labor, your actual physical meat-suit body. Welcome to ancient Rome, where the state had opinions about your skeleton that would make modern HR departments spontaneously combust. Roman law had this delightful concept called dominion, the idea that certain bodies weren't just people, they were things, legal objects. And the law didn't treat this like a philosophical gray area. It drew up paperwork. It held trials. It made very confident decisions about whose body counted as a person and whose counted as furniture with a pulse. Slaves, for example, were classified under the same legal category as livestock. Not metaphorically, literally. If someone damaged your slave, broke their arm, say, or gave them a mysterious limp, the legal remedy was the same as if someone had kicked your horse. Property damage. You'd file a claim. A judge would assess the depreciation in value. The human being in question would sit there while lawyers debated how much their bruised femur had affected their market worth. But here's where it gets even weirder. Free Roman citizens weren't entirely off the hook either. Your body could be pledged as collateral for debt. Miss a payment, and creditors had a legal right to take physical custody of you until the debt was settled. There was even an archaic law, the Lex Poedelia eventually abolished it, but it existed, that allowed multiple creditors to literally divide a debtor's body between them if he died owing several people money. Historians debate whether this was ever practiced literally or was just legal theater to scare deadbeats. Either way, someone thought it was a reasonable thing to put in writing. The psychological impact of this kind of law isn't subtle. When a society codifies that some bodies are objects, it doesn't just change legal outcomes. It rewires how every person in that society perceives themselves relative to power. You internalize it. You police yourself. You become complicit in your own erasure. Psychologists call this depersonalization under authoritative systems, the slow erosion of self-concept when institutions treat personhood as a conditional privilege rather than a baseline fact. Basically, the Roman legal system looked at the human body and said, "Cool. What's it worth?" And everyone just nodded and wrote it down. Number 9. The length of your beard was a crime. Some people have a fear of buttons. Ancient Persians, apparently, had a fear of untrimmed facial hair on the wrong kind of person. And they dealt with that fear the way all ancient civilizations dealt with their anxieties, by making it a punishable offense. Under various ancient Persian imperial codes, the style, length, and presentation of a man's beard were not personal choices. They were status declarations enforced by law. Noblemen and warriors had specific grooming standards that were legally mandated, and wearing your beard in a style above your station was treated as a form of identity fraud. You were, in the eyes of the law, impersonating a class of person you had no right to impersonate with your face. This sounds absurd until you realize we still do versions of this constantly. Dress codes, uniform regulations, professional appearance standards, we've just replaced the executioner with an HR email. But in ancient Persia, the consequences were considerably more dramatic. Certain accounts describe punishments ranging from public shaving, a profound humiliation in a culture where beards signaled divine favor and virility, to fines, imprisonment, and in extreme cases involving soldiers, physical disfigurement. The psychology here is actually fascinating and deeply human. Appearance regulation is almost always about power legibility, making sure you can look at someone and instantly know where they rank. Psychologists studying social stratification cues have found that humans are extraordinarily quick to make hierarchical judgments based on appearance, and ancient law was essentially trying to hardcode those judgments so no one could hack the system by growing an ambitious beard. Your body, in this framework, was a walking status report. And if your status report contained inaccurate information, the state reserved the right to edit it, with a razor, against your will, in front of people. The really disturbing part isn't the punishment. It's the assumption underneath it, that your physical presentation is a public document that the government has editorial rights over. That your face, specifically the hair on your face, is not yours to cure it. It belongs to the social order. You're just the one maintaining it, which honestly tracks with a lot of modern dress code arguments. We've just agreed, collectively, to pretend the power dynamic isn't as naked as it used to be. It is. We're just better at dressing it up. Beards included. Number 8. Dead bodies had more rights than living ones. Here's a sentence that should not be historically accurate but absolutely is. In several ancient civilizations, your corpse had more legal protections than your living body did. Let that marinate for a second. You could be beaten, enslaved, mutilated, and sold while alive, but the moment you died, suddenly everyone got very respectful and ceremonial about the whole thing. Ancient Egyptian law took the sanctity of the dead with extraordinary seriousness. Desecrating a corpse was considered one of the most severe crimes a person could commit, punishable by death, exile, or the erasure of your own name from public record, which, in Egyptian cosmology, was arguably worse than death because it meant your soul had nowhere to go. Meanwhile, living laborers who built the very tombs protecting those sacred bodies could be worked until they physically collapsed, fed minimum rations, and replaced without ceremony. The legal logic was theological, not hypocritical, at least not intentionally. The body after death was a vessel for the Ka, the spiritual double that needed a preserved physical home to navigate the afterlife. Damage the body, and you weren't just committing vandalism. You were committing cosmic sabotage against someone's eternal existence. The law treated this as a crime against the divine order itself. But psychologically, this creates a genuinely eerie inversion. It implies that the body only acquires full, legally protected status once it's no longer capable of suffering. Which, when you say it out loud, sounds less like theology and more like a very dark joke about bureaucratic timing. Anthropologists studying mortuary law cross-culturally have noted that societies with the most elaborate protections for the dead often use those protections as a substitute for rights they never extended to the living. It's performative dignity, a way of making the social order feel compassionate in retrospect, after the window for actual compassion has closed permanently. Your body apparently peaked legally at the exact moment it stopped being useful to you. Thanks, ancient Egypt. Really nailed the timing on that one. Number 7. Women's bodies as agricultural policy. Somewhere in ancient Mesopotamia, a lawmaker looked at a wheat field, looked at a woman, and thought, these are basically the same problem, and then wrote legislation accordingly. Not as a metaphor, as actual governing philosophy. The Code of Hammurabi, one of the oldest written legal codes in human history, and a document that historians love to cite as evidence of early civilization sophistication, contains multiple laws that treat female reproductive capacity as a form of agricultural resource management. Women who miscarried due to being struck by another person were covered under property damage law. The compensation wasn't paid to the woman. It was paid to her father or husband, because the loss was assessed as damage to their asset, not as harm to her body. If a woman died from the same assault, there was a separate clause, but again, the framing was economic. The law calculated losses in terms of productive capacity, inheritance disruption, and household resource damage. The woman herself was the medium through which the actual legal harm, the harm to property, to lineage, to male economic interest, was measured. This wasn't unique to Babylon. Variations of reproductive body as resource law appear in ancient Assyrian codes, early Hebrew law, Greek city-state regulations, and Roman family law. The specific details varied, but the underlying architecture was consistent. The female body was legally significant primarily in its capacity to produce heirs, and that capacity was owned by the men legally responsible for it. The psychological consequence of growing up inside this kind of legal framework is hard to overstate. When the law consistently reflects that your body's value is external, held by someone else, assessed by someone else, compensated to someone else, it doesn't just affect legal outcomes. It shapes identity formation at a fundamental level. Psychologists studying objectification theory describe how chronic external treatment of the body as an instrument eventually causes people to self-objectify, to monitor and evaluate their own bodies from an outsider's perspective, as if they were property assessing their own market condition. Ancient Mesopotamia didn't invent that psychological mechanism, but it did write it into law, press it into clay tablets, and distribute it across an empire, which is a remarkably efficient way to make sure everyone gets the message. Number 6. Your teeth could testify against you. Picture this. You're standing trial in ancient Rome or medieval Europe, and the judge isn't primarily interested in your alibi, your witnesses, or your version of events. He's interested in your teeth, your skin, the specific geography of scars on your back. Because in several ancient legal traditions, the body wasn't just the subject of the law, it was treated as a witness. A physical document that could be read, interpreted, and used as evidence in ways the person inhabiting it had absolutely no say over. Roman legal practice included the formal examination of slaves' bodies as evidentiary procedure. If a slave was called to provide testimony, that testimony was only considered legally valid if it was obtained under torture. Not as a last resort, as standard protocol. The reasoning, and Roman jurists defended this with completely straight faces, was that slaves were so conditioned to obey their masters that their words couldn't be trusted unless pain overrode their social programming. The body under duress, apparently, was more honest than the person just talking. This was written into legal theory by serious thinkers who genuinely believed they were designing a rational system. Cicero argued against it. Most of his colleagues shrugged and kept the policy. But beyond Rome, the body as evidence concept ran even deeper. In ancient Germanic law and later medieval European codes, physical characteristics, birthmarks, unusual features, bodily anomalies, could be legally interpreted as signs of guilt, divine disfavor, or supernatural involvement. A woman with a numb patch of skin could have that patch used as evidence of a pact with the devil. The body was a text, and the court reserved the right to read it however the political moment required. Forensic psychologists studying false confession research have extensively documented what happens when legal systems treat physical coercion as a path to truth. You get compliance, not accuracy. People say whatever stops the pain. The body does testify under those conditions, just not truthfully. Testifies to its own limits, to the specific threshold at which a nervous system overrides everything else. Ancient Rome built an entire legal institution on that threshold and called it justice, which is either deeply tragic, deeply ironic, or both, depending on how much coffee you've had. Number 5. The state owned your pain. There's a particular kind of audacity required to look at a suffering human being and say, actually, that suffering belongs to us. Ancient legal systems had that audacity in abundance, and they backed it up with paperwork. In ancient Sparta, physical pain wasn't just something that happened to your body, it was a state resource. The entire Spartan legal and social framework was built around the concept that your body's capacity to endure suffering was public property, to be allocated, managed, and optimized by the city-state according to its military needs. Private pain, the kind that existed for your benefit, your growth, your personal narrative, was essentially illegal, or at least deeply suspicious. The agoge, the brutal Spartan education and training system, wasn't just a school. It was a legal institution. Boys were removed from their families at age 7 by law, not custom, and subjected to a regime of deliberate physical hardship that included restricted food, mandatory fighting, exposure to cold, and ritualized beatings, including an annual ceremony at the altar of Artemis Orthia where boys were flogged until they bled, and the one who endured the longest without showing pain was celebrated as a winner. Crowds watched. It was a public event. People brought their families. The legal logic was militaristic and collective. Your body existed to serve Sparta, so your body's pain threshold was a civic asset that needed development and public verification. Showing pain was not just weakness, it was a form of theft. You were squandering state resources by feeling things too loudly. Psychologists studying Stoic coping under authoritarian systems have found that cultures enforcing emotional and physical suppression don't actually produce people who feel less. They produce people who dissociate more effectively. The pain doesn't disappear. It relocates. It goes internal, surfaces in different forms, and creates psychological profiles that look composed from the outside and fractured from the inside. Sparta produced extraordinary soldiers and a civilization that collapsed relatively quickly once the military pressure sustaining its social order eased. Historians have a lot of theories about why. One of them, increasingly, involves the psychological cost of spending generations telling an entire population that their interior experience was the property of the state. Turns out, if you legislate away a people's relationship to their own suffering, you don't get invincibility. You get a very efficient machine with a significant invisible crack running through the middle of it, which is a lesson that has been available for approximately 2,000 years and continues to go unlearned with remarkable consistency. Number 4. Disfigurement as legal currency. Ancient law loved symmetry. Not the aesthetic kind, the punitive kind. The idea that if you damaged someone's body, the correct legal remedy was to have your body damaged in the exact same way, in the exact same place, by an official whose job was to make the geometry of suffering match up correctly. An eye for an eye wasn't a metaphor in early legal codes. It was a measurement system. The lex talionis, the law of retaliation, appears in the Code of Hammurabi, Mosaic law, ancient Assyrian codes, and early Roman legal tradition. The principle sounds simple: proportional punishment, matched to the crime. But the implementation was spectacularly literal. If you knocked out someone's tooth, a designated state official knocked out your tooth. If you broke a man's bone, your corresponding bone was broken. The body became a ledger, and justice meant balancing the books with matching entries on both sides. The practical application was even more specific than it sounds. Hammurabi's code distinguished carefully between whose body was damaged and whose body would be doing the retaliating. If a nobleman knocked out the tooth of another nobleman, the nobleman's tooth came out. If a nobleman knocked out a commoner's tooth, he paid a fine instead. If a commoner knocked out a nobleman's tooth, well, the commoner lost significantly more than a tooth. The symmetry had a class system built into it, which somewhat undermines the whole proportional justice pitch. What this created psychologically is a legal culture where your body was simultaneously the instrument of wrong and the currency of correction. Your flesh was the medium through which society communicated its displeasure. Behavioral economists studying punishment psychology have found that humans have a deeply wired sense of fairness that responds strongly to visible, proportional consequences. We're actually neurologically satisfied by matched retaliation in a way that abstract fines don't replicate. Ancient law wasn't designed by psychologists, but it was accidentally very well calibrated to the parts of the human brain that track social reciprocity. The disturbing part isn't the logic. The logic almost makes sense. The disturbing part is the image of a professional, someone with an official title and presumably a regular salary, whose entire job was to show up at a sentencing and recreate a specific physical injury on a specific part of a specific person's body with clinical precision. That person went home for dinner afterward, presumably had a normal evening, maybe complained about work. Justice apparently had a very specific job description, an excellent hand-eye coordination. Number 3. Postmortem punishment, when death wasn't enough. Some ancient legal systems looked at death and saw a finish line. Others looked at death and thought, we're just getting started. If you believed your crimes had earned you the maximum penalty, and that the maximum penalty would at least come with the relief of it being over, several ancient legal traditions would like to have a word with you. Specifically, they would like to have that word over your exhumed corpse. Posthumous punishment, the legal prosecution, conviction, and physical punishment of dead bodies, was practiced with complete procedural seriousness across multiple ancient and medieval legal systems. In ancient Rome, a person condemned for treason after death could have their body denied burial, thrown in the Tiber River, or subjected to symbolic degradation rituals. Their name was erased from public records. Their will was voided. Their property was seized retroactively. Their memory was legally executed alongside whatever remained of their physical form. The Persians practiced a version of this too. Certain criminals were subjected to scaphism, a method of execution so prolonged and elaborate it almost reads like a legal argument, and if they died before the punishment was deemed complete, the punishment continued on the body anyway because the law had made a commitment and intended to honor it. Medieval European law escalated this into full theatrical courtroom procedure. The Cadaver Synod of 897 AD is perhaps the most surreal example in recorded legal history. Pope Formosus was dug up 9 months after his death, dressed in papal robes, propped in a chair, and put on trial for perjury and various ecclesiastical crimes. A deacon was appointed to speak on his behalf. The corpse, declining to mount a vigorous defense, was found guilty. His papal vestments were torn off, the fingers used for consecration were cut from his hand, and his body was thrown in the Tiber. He was later exonerated. The Pope who ordered the trial was subsequently strangled, which at least showed some consistency. Forensic psychologists studying symbolic punishment have noted that postmortem legal action serves almost no rational deterrent function. Dead people are famously unresponsive to consequences. What it actually serves is collective psychological and political theater. It's the legal system performing the completeness of its own authority, saying clearly to anyone watching, our jurisdiction does not end at the boundary of your life. We reach further than that. Plan accordingly. Its control extended past its logical limit, which is essentially the defining feature of ancient legal excess. The body, even emptied of the person who inhabited it, remained subject to the rules, which is either a profound statement about how societies conceptualize justice, or evidence that some ancient lawmakers really needed a hobby. Probably both. Definitely both. Number 2. Your body was evidence of your soul's condition. Ancient medicine and ancient law had a complicated relationship with the concept of the boundary between them, mostly because they didn't believe that boundary existed. If your body looked wrong, the wrong shape, the wrong proportions, the wrong kind of marks in the wrong places, several ancient legal and theological systems had a very confident explanation for why, and that explanation came with legal consequences attached. In ancient Greece, the philosophical framework of physiognomy, the idea that a person's character, intelligence, and moral worth could be read directly from their physical appearance, wasn't fringe pseudoscience. It was mainstream intellectual thought, endorsed by Aristotle, built into medical education, and eventually absorbed into legal practice. Judges and juries were advised to consider a defendant's physical features when assessing their credibility and likely guilt. A man with small, close-set eyes was considered likely deceptive. Overly soft features suggested weakness of character. Unusual proportions were interpreted as evidence of unusual inner states. This wasn't informal bias, it was theorized, written down, taught, and applied. Texts like the Physiognomonica laid out systematic correlations between body types and personality characteristics with the confident tone of someone explaining gravity. Courts didn't always use it formally, but the intellectual framework infected the culture thoroughly enough that it shaped judgments in ways that were assumed to be rational rather than recognized as prejudice. In ancient China, legal and medical traditions similarly intersected in ways that made the body a moral document. Certain physical conditions were interpreted as evidence of spiritual or ethical imbalance, not just misfortune but consequence. A body that manifested certain illnesses or deformities had, in this framework, produced physical evidence of interior wrongdoing, either in the current life or a previous one. The legal implications varied by dynasty and region, but the underlying logic created situations where sick or disabled people found themselves navigating a justice system that had already pre-read their body as a confession. The psychological damage of living inside a system that interprets your appearance as moral evidence is specific and well documented. Psychologists studying stigma and self-concept consistently find that when social and legal institutions treat physical difference as evidence of character deficiency, the people targeted internalize that judgment with striking efficiency. You don't just face external discrimination, you begin to assess your own worth through the lens that the institution has handed you. You read yourself the same way the court reads you. Guilty on arrival, sentenced by your own reflection. What makes this particularly insidious is that it dressed itself up as science. It had taxonomies. It had diagrams. It had serious men with serious credentials arguing about the precise slope of a nose and what it revealed about a man's fitness for civic life. It was prejudice that had done enough homework to feel like scholarship, which made it significantly harder to argue against and significantly easier to legislate. Your body in this legal universe was a symptom. Whether you had done anything wrong was almost secondary. The real question was what your cheekbones suggested about your potential. Number 1. You could be legally declared not a body at all. At the very top of this list, which has already covered state-owned pain, posthumous trials, and beard crime, sits the most quietly devastating legal concept of the ancient world. The formal, procedural, fully documented declaration that a living, breathing, feeling human being was not, legally speaking, a person. Not property. Not a criminal. Not even a body deserving of punishment. Simply not there. a legal non-entity walking around in a physical shell that the law declined to acknowledge. Roman law had a concept called capitis diminutio maxima, maximum reduction of legal personhood. Under this classification, a free person who was enslaved, exiled, or subjected to certain extreme punishments didn't just lose rights. They lost legal existence. Their personhood was formally subtracted. Contracts they had signed became void. Property they had owned evaporated. Family relationships they had held, father, husband, citizen, were legally dissolved as if they had never existed. The person continued to breathe, eat, occupy physical space, and experience the full interior richness of a human life. The law simply refused to process any of it. The Athenians had a timia, a declaration of civic death applied to people who had violated certain laws or defaulted on public obligations. An atomos person could be killed by any citizen without legal consequence, because in the eyes of the state you weren't killing a person. You were removing an object that had been classified as a nuisance. The person subject to a timia didn't cease to exist. They ceased to count. Ancient Indian legal texts contain provisions under which individuals of certain castes existed in such a comprehensively subordinated legal state that their testimony was inadmissible, their ownership of anything was theoretical at best, and their physical suffering registered in the legal system only insofar as it affected the people who held power over them. The body was present. The person was an administrative fiction the law hadn't bothered to create. Psychologists studying social death, a concept developed by Orlando Patterson in his landmark work on slavery, describe it as the condition of existing in a community while being systematically excluded from its moral universe. You are physically present but socially non-existent. You can be seen but not recognized. You can suffer but not be wronged. The legal mechanisms of ancient civilization didn't just enable this condition, they formalized it, stamped it with official seals, and filed it in triplicate. What makes this the most disturbing entry on this entire list isn't the violence of it, though the violence is real. It's the bureaucratic neatness. The violence of ancient law at its worst wasn't chaotic, it was organized. It made forms. It followed procedure. It had a calm, administrative quality that somehow makes it harder to look at than open cruelty would be. Because open cruelty at least acknowledges that there's someone there to be cruel to. The legal declaration of non-personhood doesn't even extend that much. It just looks through you, adjusts its paperwork, and moves on to the next item on the agenda. Your body, your pain, your interior experience of being alive, irrelevant. The law had already decided what you were, and what you were was nothing it needed to account for. And somewhere in that ancient courtroom, a scribe wrote it all down very neatly, and probably went home feeling like he'd had a productive day. That's all for today. I'll be making similar videos in the future. Subscribe to see them.